Chapter 2. 4 Reasons for Studying Law. Dear Alex, as promised, here's my follow-up letter setting out the various reasons why I think people should be interested in studying law at university. I've got 4 of them. Let's get straight into them. Brain training. The first reason for studying law at university is that doing a law degree is great at helping you learn how to think carefully, imaginatively, and sensibly. I am not sure how much schools do nowadays in helping their students to think. Students I meet say that much more emphasis is placed on rote learning and regurgitating information. Certainly, when I ask them to discuss a situation raising some issue of law, their responses seem to be much more guided by their instincts and emotions, rather than by carefully and imaginatively reasoning their way to a sensible conclusion. I find this really sad. In these benighted times, we need more than ever people who can think properly, and if you haven't acquired that ability at school, then doing a law degree is a great way to catch up. So how does studying law help you to think properly? Well, consider the following situation which I sometimes ask students to think about. You are told that someone commits murder if his or her actions cause another to die, and he or she performed those actions intending to kill someone or to cause someone to suffer serious bodily harm, and he or she had no lawful justification or excuse for acting as he or she did. In light of this information, consider whether D has committed murder in the following situation. T, a notorious terrorist, kidnaps D's wife and 2 children and threatens to kill them unless D delivers a package containing a bomb to V, the ambassador at an embassy to which D has access. D delivers the package. When V opens the package, it explodes and V dies. So what do you think? If you are thinking carefully, you will note that the definition of murder with which you have been supplied has 3 elements, and all of them need to be present for murder to be committed. So we need to establish that 1. D's actions caused V to die, and 2. D acted as he did with an intent to kill or an intent to cause serious bodily harm, and 3D had no lawful justification or excuse for acting as he did. Taking each element in turn, it is clear that D's actions did cause V to die. Had he not done what he did, V would not have been killed. But did D have an intent to kill when he acted as he did? This is where a lot of students trip up. They say that if D knew that the package contained a bomb, then he intended to kill V when he delivered the bomb. In that situation, D will certainly have foreseen that V would very probably die if he delivered the package. But if we are thinking carefully, we will wonder whether we can always be said to intend what we foresee will happen as a result of our actions. After all, why would we have 2 different words for what we intend and what we foresee if they were the same thing? In order to test out whether we can always be said to intend something that we foresee will happen as a result of our actions, we have to use our imagination to come up with a hypothetical example to test this out. For example, I foresee that writing this letter to you will result in my getting quite tired. Thinking is hard work, but does that mean that I intend to get tired when I write to you? That sounds pretty implausible. Intending something to happen seems to be different from foreseeing that something will happen. If you intend something to happen, you try to make it happen, and when D delivers the package, he isn't trying to kill V. He is just trying to deliver the package. So if we are careful in the way we think about the situation presented above, we will conclude that D is not guilty of murder. But what about this situation? T, a notorious terrorist, kidnaps D's wife and 2 children and threatens to kill them unless D kills his best friend V, who is an important politician. D kills V. Here D's actions have caused V to die, and D acted as he did with an intention to kill. He was trying to kill V when he killed V. So D will have committed murder in this situation, unless he had a lawful justification or excuse for acting as he did. At this point, instincts or emotions will lead a lot of students to say that he did have a justification or excuse for acting as he did. After all, if he hadn't done what he did, 3 people would have died. And surely 3 people surviving and 1 person dying is better than 3 people dying and 1 person surviving. Well, let's think about it. If we were thinking carefully, we would note that the definition of murder refers to someone having no lawful justification or excuse for acting as they did. The fact that two different words are used here might indicate that they are referring to two different things. When we say that X's actions are justified, we seem to be saying that X did the right thing in the circumstances. But when we say that X's actions are excused, we seem to be saying something different. Doing the right thing needs no excuse. It's only when you do the wrong thing that you might seek to be excused for what you did. And when people ask to be excused, they almost always do so on the basis that their conduct, while wrong and regrettable, was so understandable that it would be wrong to blame them for acting as they did. So this indicates that D has two ways of arguing that the final element in the definition of murder was not present in his case. He could argue that 1. He did the right thing in acting as he did. Or 2. He did the wrong thing in acting as he did. But his actions were so understandable that it would be wrong to blame him for acting as he did. So let's think about whether he can make either of these claims. First of all, did D do the right thing in doing what he did? As we have just seen, a lot of students instinctively think that he did 3 people living, and 1 person dying is better than 3 people dying and 1 person surviving. But let's think about that for a second, with the help of another hypothetical example. Suppose that you suffer from some medical condition, which means that you only have 1 year to live. But you are told that your condition can be completely cured by a full-body blood transfusion, which would involve replacing your entire blood supply with blood extracted from X's body. The transfusion would have the effect of killing X, who would, as a result, have to be forced into donating his blood, but will save your life. Would you want to go ahead with the blood transfusion? I think most people would say no. They would not want their continued existence to be paid for with the killing of an innocent person like X. If this is right, then D's wife and 2 children might each prefer that D not preserve their lives by killing V. And if that is right, then it becomes much harder to argue that D did the right thing in killing V, if the very people for whose sake he was killing V would have preferred him not to do so. Then it's hard to find a basis for arguing that he did the right thing in killing V. D might find it easier to argue that he should be excused for doing what he did. He would claim that while he might have done the wrong thing in killing V, it was understandable that he found it difficult, if not impossible, to stand up to T's threats and allow T to kill his wife and children. Different people might have different views on this. This is what Lord Hailsham thought, in rejecting the idea that an ordinary person could not be expected to stand up to T's threats, and that it would have required D to exhibit an extraordinary degree of heroism to do so. I must say that I do not at all accept in relation to the defense of murder. It is either good morals, good policy, or good law to suggest that the ordinary man of reasonable fortitude is not to be supposed to be capable of heroism if he is asked to take an innocent life rather than sacrifice his own. Doubtless in actual practice many will succumb to temptation, but many will not, and I do not believe that as a concession to human frailty, the former should be exempt from liability to criminal sanctions if they do. I have known in my own lifetime of too many acts of heroism by ordinary human beings of no more than ordinary fortitude to regard a law as either just or humane, which withdraws the protection of the criminal law from the innocent victim and casts the cloak of its protection upon the coward and the poltroon in the name of a concession to human frailty. What do you think? Note that Lord Hailsham is only talking there of a situation where someone kills an innocent person in order to save his own life. Might things be different where you kill in order to save the lives of other people whom you love? This is just one example of how studying law encourages you to think straight. If you want some other examples, my college, Pembroke College, in Cambridge, has set up a virtual classroom in law on its website. You can access it most easily through my website www.mcbridesguides.com. Hover the cursor over the Legal Skills section of the website and click on the Virtual Classroom part of the drop-down menu. All of the exercises under the Legal Skills section of the classroom test out various different reasoning skills that become second nature to those who study law. Rhetoric, So, the first reason for studying law at university is that it helps sharpen your mind. The second reason for studying law is that it helps sharpen your tongue and pen as well. Studying law is the closest you can come to getting a course in what the ancient Greeks and Romans would have called rhetoric, the art of persuading someone to adopt a particular point of view by speaking and writing effectively. Rhetoric is not something that is taught anymore in schools, and it shows when my students come to university. As a general rule, they don't know how to write effective essays. Essays that argue effectively for a particular point of view. Their essays are full of, on the one hand, on the other hand. It is necessary to bear the following points in mind. It might be argued that they are very painful to read and must be pretty boring to write. There is no sense of any spark of life or inspiration behind them. No sense that the essay is animated by a positive desire to change the way the reader thinks about things. It is all just lifeless going through the motions. Studying law at university helps change all that. Because law is, at base, all about a conversation about what sort of society we should live in. The one immutable rule for lawyers is, express yourself clearly or die. Let's call this the iron rule of lawyering. If you cannot express yourself clearly, there is no room for you in the law. So, for example, if you are a lawmaker, obscurity will doom to failure all your efforts at making law. Lon Fuller makes this point vividly in a parable about a would-be lawmaker Rex. Rex announced to his subjects that henceforth he would act as a judge in any disputes that might arise among them. In this way, he hoped that by proceeding case by case, he would gradually work out a system of rules that could be incorporated in a code. Unfortunately, the venture failed completely. After he had handed down literally hundreds of decisions, neither he nor his subjects could detect in those decisions any pattern whatsoever. Such tentatives toward generalization as were to be found in his opinions only compounded the confusion, for they gave false leads to his subjects, and threw his own meager powers of judgment off balance in the decision of later cases. Rex now realized that there was no escape from a published code declaring the rules to be applied in future disputes. Rex worked diligently on a revised code, and finally announced that it would shortly be published. This announcement was received with universal gratification. The dismay of Rex's subjects was all the more intense, therefore, when his code became available, and it was discovered that it was truly a masterpiece of obscurity. Legal experts who studied it declared that there was not a single sentence in it that could be understood either by an ordinary citizen or by a trained lawyer. Indignation became general, and soon a picket appeared before the Royal One Palace carrying a sign that read, "How can anybody follow a rule that nobody can understand?" I don't know of any judge whose voice is still listened to in the ongoing conversation among lawmakers about what sort of society we should live in who is not a master at expressing himself or herself clearly. Have a look at any of the judgments quoted in my last letter to see some examples of judges expressing themselves extremely clearly. Obscure and unclear judgments have a very short shelf life. The same is true of statutory provisions. Any statutory provision that is not expressed clearly enough to be understood is soon withdrawn or revised, or attracts such a wealth of case law trying to make it clear what the statutory provision says that you might as well just retain the case law and throw away the underlying provision. The iron rule of lawyering also applies to legal academics writing about the law. A legal academic who cannot make him or herself understood by his or her peers will have no future as an academic. I can count on the fingers of one hand the number of legal academics who have achieved some kind of world renown without being able to write really clearly. But as soon as they retire, their renown will quickly fade as people become less and less willing to make the effort to try to understand what they were trying to say. Law has seemed immune from the modern fad for identifying obscurity with profundity that has invaded other disciplines such as English or theology or philosophy or any of the social sciences other than law. Students in those disciplines have to weary their minds trying to make sense of rubbish like this. Both Pound's Portrait d'une femme and Eliot's Portrait of a Lady constitute a kind of opinion which, as we shall see, is a pattern they used a great deal. The parallel actions function as a plot and counterplot which enrich each other by their interplay. Poe's Descent into the Maelstrom has structurally much in common with the vortices of the cantos. Similarly, the Sargasso Sea is a vortex that attracts multitudinous objects, but which also tosses things up again in recognizable patterns which serve for survival. Law students, in contrast, get to feast on gems like this. A search warrant has to be specifically justified, or it gives no authority to enter premises or take away goods. So held Lord Camden. A good thing. The policeman may, however, seize any suspicious goods he finds. So holds our Court of Appeal. A bad thing. Lord Denning Mr. explains that there are more wicked people about now. More innocent people, consequently, must suffer without redress. Diplock LJ refuses to follow the liberal reasoning of Intick v. Carrington on the ground that our police forces are better today. Might they not become better still if they had to pay for their mistakes? Salmon LJ said that the warrant could have been drawn so as to protect the police. His decision means that they needn't bother. Chic Fashions West Wales Limited v. Jones 1968 2WR 201. Can it be said on occasion? Judges give effect in court to political views which might fairly be described as right of center upper middle class. I think it is possible to argue that they do, and that, on occasion, when free to do otherwise, they either go out of their way to protect the well-to-do, or make decisions within the framework of tolerated debate, which is congenial to that group only. Some litigation is conducted with little overt sensitivity to the political context in which it takes place. It is not that two views are debated and one rejected, but rather, as in a one-party state, only two variants of one view. Some judges like to say that the most important person in court is the party who is going to lose. Every effort must be made to persuade him that his views have been listened to. They are also often aware that there are parties not before the court for whom the matter is at least as important. What has to be said is that there are sometimes political non-party losers whose views are wholly unrepresented in the debate. We are all of us in favor of protecting the rights of the individual, but it is possible to disagree as to what those rights are when they meet with the novel demands of a welfare state. Collectivism will not hold the same terror for the down and out as it holds for the up and in. Practicing lawyers, such as solicitors who represent clients in legal matters outside court and barristers who represent clients in legal matters inside court, are also bound by the iron rule. Solicitors who cannot advise their clients clearly as to their legal rights will lose those clients very quickly. A barrister who cannot argue a case effectively in court will soon find him or herself running short of briefs. Finally, law students are not exempt from the iron rule. Law students are expected to write essays that make effective arguments in favor of a particular view of what the law says, or what it should say. In exams, these essays tend to have to be written in as little as 40 minutes to an hour. So law students who want to be successful as law students need to learn how to say a lot, and to say it clearly in 2 or 3 pages. This is very difficult. Brevity is always much harder to achieve than loquaciousness. Blaise Pascal, the French mathematician and philosopher, once joked, "I have made this letter longer than usual, because I lacked the time to make it short." But you cannot do well as a law student without learning how to get to the point quickly and make every word count. It is no accident, I think, that so many of the greatest orators of all time, such as Demosthenes, Cicero, Daniel Webster, Henry Clay, Abraham Lincoln, William Jennings Bryan, and even Barack Obama, in our own time were all lawyers before going on to achieve fame as great speechmakers. It's no accident either that the speech for which Abraham Lincoln is most famous, the Gettysburg Address, is only 272 words long. In contrast, the professor of Greek literature who spoke before Lincoln at the dedication ceremony at Gettysburg spoke for 2 hours. Politics. The third reason for studying law is that it helps you to form your own views as to what sort of society we should live in, and puts you in a good position to provide an informed contribution to the future shaping of our society, whether simply by voting in elections or by working within politics yourself. Of course, it might be argued that studying philosophy at university would serve just as well to prepare you for a career in politics. However, there is a crucial difference. When you study philosophy, you are looking at a set of thinkers' abstract ideas as to how society should be ordered. But law exists at the cutting edge of shaping society. As a result, lawmakers have a special responsibility that philosophers are not subject to the ideas for arranging society that lawmakers give effect to have to work in practice. They have to do more good than harm. If they don't, then the lawmaker's efforts will eventually be overturned. Once the lawmaker is off the scene, either fired or retired, his or her contributions to the law will be reversed, and the law will be put on a more beneficent path. Dr. Martin Luther King Jr. liked to say that the arc of the moral universe is long, but it bends towards justice. Whether that is true or not of the moral universe, it is certainly true of legal systems. In Lord Mansfield's striking phrase, the law eventually works itself pure of its past failures. So when you study law, you develop a practical sense of what works and what doesn't work in ordering society. That, I think, is a very important thing to know if you are going to get involved in politics. And that is not something that studying abstract political theories on a philosophy course can give you. Indeed, it is striking how many philosophical ideas, once put into practice, have proven to have terrible consequences. Moreover, studying law, and in particular, English law, introduces you to a particular method of effecting social change. This is perhaps English law's greatest contribution to the world, the common law method of making law. All lawmakers are faced with the problem of their lack of omniscience, the fact that they cannot anticipate all the consequences of their lawmaking activity, and can end up doing much more harm than good through that activity. The common law method of making law was the English lawyer's solution to this problem. Until the 20th century, the English law was primarily common law. That is, law that had been developed as a result of the decisions of the courts in concrete cases. And in developing the law, the courts would decide on a case-by-case basis what the law said. This method of making law, the common law method, allowed the English courts a lot of leeway to experiment with the law. In a particular case, one judge might suggest that the law said X. In later cases, other judges would have a look at this suggestion and ignore it, modify it, apply it, or expand on it. And then other judges in further cases would see what they made of that development and adjust it accordingly. In this way, the common law, the law as developed in the courts, emerged out of a process of trial and error, where only rules and doctrines that generally satisfied the judges as being reasonable would survive to become part of the established common law. In this way, the lawmaker's problem of lack of omniscience was avoided. If new situations came up that had not been anticipated before, the rules and doctrines of the common law could be adjusted to take account of them, and a new but necessarily temporary understanding of what those rules and doctrines were would come into existence. As I said, up until the 20th century, this was the way in which law was developed in England. One consequence of this was that it was difficult to say with any certainty what the law said on a particular question. For that, you would have to look at all the previous cases that had some bearing on that question, and make educated guesses as to what the courts would say on that question, given those previous decisions. But this method of lawmaking was the humble tribute that English lawyers paid to their own fallibility and inability to predict the future. They adopted a method of lawmaking that was flexible enough to make their incapacity irrelevant. And this recognition that lawmakers could not completely anticipate the future, and the consequent desire for lots of flexibility in administering the law, had a huge political effect. It may be the most important reason why the UK managed to get through the 19th and 20th centuries without any kind of revolution. Unlike virtually every country on the continent, the preference that English lawyers had for changing the law through a cautious, step-by-step process made English society as a whole resistant to, and suspicious of, revolutionaries who claimed that with one big leap forward society could be transformed into a utopian ideal. Of course, in the 20th century, things changed. Legislation laying down general rules and provisions for people to abide by and take advantage of became a much more dominant source of law. and this reflected a utopian turn in political thinking, whereby it became much more acceptable to think that a more perfect society could be magicked into existence through legislative fiat. But it is precisely because this utopian turn still remains very dominant in our politics and philosophical discussions of politics that those entering politics should be exposed to the alternative, more organic and incremental, approaches to changing society that were once second nature to our lawmakers. But you can only be exposed to this alternative approach by studying it in action, in the development of the common law, legal training. I've left until last the reason you might have expected me to start with that doing a law degree is the best preparation you can have for becoming a practicing lawyer. This is for 3 reasons. First, I didn't want you to get the impression that you should only consider studying law if you want to become a practicing lawyer. The skills and knowledge that you acquire as a law student are invaluable for a range of different careers. Secondly, I'm not sure that people should choose to study a subject at university based purely on careers-based considerations. You should use your time at university to study a subject you would love to explore in depth. Thirdly, there are people who endorse what we can call the astonishing hypothesis that studying law at university is not the best preparation for becoming a practicing lawyer. I call this the astonishing hypothesis because I think people would be astonished to be told that doing a degree in medicine is not the best preparation for becoming a doctor, or that doing an engineering degree is not the best preparation for becoming an engineer. So it would be similarly astonishing if studying law at university were not the best preparation for becoming a lawyer. And I didn't want you to think that, if the astonishing hypothesis turned out astonishingly to be correct, there was no reason to study law at university. For the purposes of this letter, I'll just take the commonsensical position that the astonishing hypothesis isn't true. If you want me to deal with it, I'll address that in another letter. But for the time being, let's assume that doing a law degree is the best preparation for becoming a practicing lawyer. But this only gives you a reason to study law if you want or think you might want to become a practicing lawyer. And you may have your doubts about that. Many people think that you have to sell your soul to become a lawyer. I understand why people might think that way. Anyone who has the power to argue convincingly on either side of a case will always attract suspicion. One of the first philosophers in history, Socrates, was executed in Athens in 399 BC. One of the charges in the indictment against him was that he had the power to make the weaker case seem stronger. The lawyer's ability to take either side of a case seems to indicate an unprincipled indifference to right and wrong. Lawyers, it is suspected, sell out their consciences and simply seek to represent whichever side in a dispute is willing to pay them the most for their services. Let me act like a typical lawyer and put the other side of the case. Deciding to become a lawyer is just as morally worthwhile as choosing to become a doctor or a teacher. This is because you can't have a functioning legal system without lawyers, and a society's legal system is as vitally important to the flourishing of the people living in that society as are that society's health or education systems. We tend to forget this in Western societies because we take our legal systems and the benefits we obtain from living under our legal systems for granted. To appreciate how important our legal systems are, I want you to do 2 things. First of all, imagine what it would be like to live in a society where everything is permitted. We don't have to try too hard to do this. We just have to watch or read the news from other parts of the world to see examples of societies that have no legal systems worth speaking of, where there are no effective limits on what the state may do to its citizens, or what its citizens may do to each other. Life in such societies is solitary, poor, nasty, brutish, and short, in the words of the philosopher Thomas Hobbes, who lived through the breakdown of social order triggered by the English Civil War. People who live in such societies are condemned to live in chaos and disorder, and to experience all the evils that flourish in conditions of chaos and disorder. Murder, rape, arson, theft, starvation, despair, suicide. The fact that we don't live in such a society is due to the fact that we live under the rule of law. That is, we live under a legal system that sets strict limits on what the state may do to us, and what we may do to each other. And those limits are by and large observed. Secondly, imagine what it would be like to live in a society where there is no trade. In other words, imagine a society where each of us has to grow or make everything we need for ourselves and our families. Again, it's not too hard to do this. Thinking about what life is like in the poorest areas of the world should give you some idea of what this sort of existence would be like. There would be no shops, no buildings bigger than those that could be built by a few pairs of hands, no guaranteed water supply, no food other than what you and your family could grow on land that you are lucky enough to have inherited, no tools to grow food other than those a single person could make for him or herself, no books, and no retirement in old age. Life in such a society would not necessarily be marked by chaos and disorder, but it would still involve a desperate and continuous struggle to stay alive. Again, the fact that we don't live in such a society is due to the fact that we live under a legal system that helps people to trade with each other. Our legal system helps people to trade with each other by doing two things in particular. First of all, it gives people something to trade by granting them legally enforceable rights over such things as their bodies, land, things, and ideas. Secondly, our legal system allows people to enter into binding contracts with each other, under which contracts their legal rights can be transferred to other people. Almost everything around you owes its existence to the fact that our legal system helps people trade with each other. Just think, for example, of the immense network of transactions that was required simply to produce the computer on which I am typing this letter. So we in the West owe everything to the legal systems under which we live. Without them, our lives would be unimaginably different and unbelievably difficult. And as you can't have a legal system without lawyers to run it, it follows that we should regard the lawyers who help to keep our legal system running as public heroes, in the same way that we regard doctors and nurses and teachers as heroic for the work they do. That, then, is my positive argument for thinking that becoming a lawyer is a morally worthwhile thing to do. But like any good lawyer, I won't close my argument without first considering and dismissing three arguments that might be made on the other side. 1. Defending evil. A question criminal lawyers are often asked is, how can you defend someone you know is guilty? And a question corporate lawyers are often asked is, how can you work for a company that pollutes the environment, pays its workers so little, does as much as it can to avoid paying taxes? The implication of both questions is that the work that the lawyer does is, at least on occasions, morally disreputable. The implication is unjustified. The short answer to both questions is that our legal system simply won't work properly if people are denied access to its benefits by lawyers who stand in judgment on them and refuse to work for them on the ground that they are not entitled to those benefits or don't deserve them. The rule of law would be fatally undermined if the mere fact that you looked guilty ensured that you were found guilty without a proper trial. Freedom to trade under the law would be similarly undermined if the mere fact that people disapproved of the way you ran your business meant that you could not find adequate representation. If our legal system is going to work properly and provide us with the benefits set out above, then lawyers have to be willing to represent unpopular or unpleasant clients and do their best for them. 2. Irrelevance. It might be argued that the UK is no longer a country that lives under the rule of law. Whatever limits UK law does place on what the state can do to us, and what we may do to each other, these limits are largely theoretical. In practice, these limits are regularly transgressed without any sanction or redress. As a serving police officer has observed, crime doesn't get investigated properly, and it hasn't done for a long time now. Just about every single reported theft of a mobile phone is recorded as lost property. You will find very, very few recorded attempted burglaries because they all get recorded as criminal damage. Crimes only get detected if they're easily solvable. There just aren't enough people to investigate crimes properly. If, say, there is a queue of 20 jobs and you have 5 officers to deal with them, it's impossible to fully investigate a crime properly. And there are some crimes that the police, seemingly, simply will not investigate. The last successful prosecution of police officers for their involvement in a death in police custody was in 1969, over 44 years ago. This is despite the fact that over 1,000 people have died in police custody in the last 12 years. So it might be argued then that the games lawyers play are largely irrelevant to the vast majority of society and make little or no contribution to ensuring that we don't slide into living in a society where everything is permitted. To borrow the legal philosopher Roberto Mangabeira Unger's striking language, lawyers are like a priesthood that has lost its faith and kept its jobs, standing in tedious embarrassment before cold altars. But even if this were true, which I don't think it is, then you have even more of a reason to want to become a lawyer. If it is true that the UK cannot be said at the moment to live under the rule of law, and it's only morality or custom that currently stands between us and our living in a society where everything is permitted, then your generation can turn things around and start rebuilding the rule of law in the UK. If the rule of law is as important as I say it is, and it is, then no enterprise could be more valuable or more urgent or make more of a contribution to people's welfare. But to get involved in this great enterprise, you have to become a lawyer. 3. Corruption. The third argument against the view that becoming a lawyer is a morally worthwhile thing to do goes as follows. Becoming a lawyer is morally dangerous. In theory, you could do a lot of good as a lawyer in exactly the ways Nick McBride describes. You could help to uphold or rebuild the rule of law in the UK by becoming a criminal lawyer or a tort lawyer, or you could help foster commerce within the UK by becoming a commercial lawyer or a corporate lawyer or a land lawyer. But lawyers also have the potential to do great evil. They can use their position to help destroy the rule of law in the UK, for example, by telling lies to the courts to ensure that guilty clients go free. And they can use their position to damage commerce, for example, by threatening their clients' competitors with expensive and potentially ruinous legal actions if they attempt to market a new invention that would transform the lives of millions. Unfortunately, the likelihood is that someone who becomes a lawyer will end up doing evil rather than good. The power of money is too great to resist a client who offers a lot of money to a lawyer in return for their doing something wrong or unethical will usually not be turned away. So whatever good you could do as a lawyer, it's better to do something else where you could do an equivalent amount of good, if not more, and not be exposed to the temptations to do evil that lawyers are routinely exposed to, and to which many lawyers succumb. This argument fails at two levels. First of all, it's simply not true that lawyers are more likely than not to end up acting immorally. If that were true, decent lawyers would be extremely hard to come by. That is not my experience. Most lawyers I come across are decent people who haven't been corrupted by money, but instead seek to fulfill their professional responsibilities as best they can. Secondly, even if the factual basis of this argument were correct, and if this argument were accepted, it would mean that no one should become a lawyer, which, as we have seen, would be ruinous for our society. A society without lawyers is one without any kind of future. If it is true that lawyers are very susceptible to being tempted to do the wrong thing, the proper response to that fact is not for people to stop becoming lawyers, but for us to strengthen the sanctions against lawyers who do the wrong thing, so as to encourage them to resist temptation. So far as morality is concerned, then, there is absolutely nothing wrong with becoming a lawyer. Quite the opposite. Lawyers are just as important to the functioning of society as teachers or doctors. However, I should sound a warning note here. Precisely because the idea of becoming a lawyer is so attractive to a lot of people, the market for jobs as lawyers, particularly to become a solicitor in a top city law firm, or a barrister in a good set of chambers, is becoming increasingly competitive. So if you think you might want to become a lawyer, you have to be realistic about what the chances are of your achieving that ambition after you leave university. A useful website to look at for this purpose is www.unistats.com. This will give you some information about what percentage of law graduates from a particular university obtain jobs once leaving university, and general levels of student satisfaction with the courses they receive. Look at the universities you are likely to be applying to and see how they rate for law. Also ask the universities themselves for any statistics that they might have on this. If they don't rate so highly, don't despair. Just be careful, think about what other careers you might be interested in, and what sort of skills and qualifications they would require. And think about whether a law degree would put you in a good position to pursue those other careers. If a career as a lawyer doesn't happen to work out for you, if the other careers you are interested in, I am thinking in particular here of teaching, require you to have done a degree other than a law degree at university, remember it is always open to you to do a non-law degree at university and then qualify to practice as a lawyer by doing a 1-year graduate diploma in law GDL, essentially a crash course in the core legal subjects at a college of law, before then going on to do a 1-year course to qualify to practice as a solicitor or a barrister. Someone who does a law degree is exempt from the need to do a GDL and can go straight on to the 1-year course to qualify to practice as a solicitor or a barrister. So if you are not confident of your chances of making it as a lawyer once you leave university, given the universities you are likely to be applying to, and there are other careers you might be interested in, and doing a non-law degree at university would be a better preparation for those careers, it might be an idea to hedge your bets by doing a non-law degree at university and then spend a year after that doing a GDL, and then see whether you can get a job as a lawyer on the basis of that and the degree you obtained at university. Summary: you don't have to want to become a lawyer to do a law degree. The analytical and rhetorical skills you will acquire in doing a law degree means that doing a law degree can provide excellent training for working in politics, journalism, business, or public service. But you shouldn't let all the lawyer jokes we both know and the caricatures of lawyers projected in the media put you off the idea of becoming a lawyer after you leave university. Lawyers perform an extremely important role in society. If you do want to become a lawyer, then doing a law degree would obviously provide you with everything you needed to become a very good and successful lawyer. However, you should be aware of how competitive it is now to become a lawyer, and you should think carefully about how likely it is that your law degree will provide you with a reliable launchpad for entering the legal profession, and how useful a law degree would be to you for other careers you might be interested in pursuing if it turned out that you weren't able to pursue a career in law. If you haven't made up your mind whether or not you want to become a lawyer, you should read a book by a journalist called Jonathan Harr. The book is called A Civil Action. It may well inspire you to become a lawyer. The book was made into a film, but try to read the book. It's much better than the film. If you want to watch some really great films about the law, get hold of To Kill a Mockingbird, The Verdict, True Believer, Indictment, The McMartin Trial, The Rainmaker, Erin Brockovich, and Flash of Genius. If those films don't make you want to become a lawyer, then nothing will. If you want to get a bit of a taste of what it is like to study law and get a better idea of how important law is to our daily lives, then I recommend that you have a look at What About Law, a book edited by 3 of my colleagues here in Cambridge: Catherine Barnard, Janet O'Sullivan, and Graham Virgo. Each chapter introduces you to a different area of law by focusing in great detail on a particular case that is relevant to that area of law. Please don't hesitate to get in touch if you have any more questions. All best wishes, Nick.